When companies are forming, the initial owners often don't have enough money to invest in that company and often will need to ask others to contribute to its success. They can do so in a variety of different ways. But what's important is to make sure that however they are getting that investment in the company, it is done in compliance with the securities laws, because if they don't do that, there can be severe consequences, both to the company as well as to anyone who's participating in the offer or the sale of those securities to the investors. And it can be personal liability. So regardless of whether the company has protected itself from liability of its owners, the people who are participating in that, at least under Arizona law, can have joint and several liability along with the company for any violations of law that may occur. So it's really important to make sure that you're doing this in compliance with the securities laws. And the securities laws can apply at many different levels. The United States federal securities laws apply to any securities offered or sold in the United States. Similarly, the laws of each state may impose additional considerations and restrictions. And not just the state in which the company is operating from, but also the state in which each investor resides. So if you are getting money from people who reside in a variety of different states, you're going to have to make sure you comply with the securities laws on a federal level, as well as each of the states in which those investors reside. So it's not an inexpensive process, but again, liability can be quite severe and sometimes absolutely give them the right to their money back, to sue for damages, attorney's fees, etc. The securities laws apply not just to the offer and sale of the securities, but also apply to the people that are doing the selling. Those people may need to be registered as a broker, dealer, or registered representative under the various securities laws. And if they don't do that, again, the sale of securities may be voidable and there could be personal liability. And the securities offerings not only have to make sure that they're exempt from registration requirements to do a public offering, but also to make sure that there's no material misstatements or omissions made to the investors, because if those occur, there could be a liability. So it's important to work with counsel and other professionals when offering and selling securities, raising money for your company, to make sure you're doing it in compliance with these laws. And these laws are going to apply whether you're getting an equity investment or issuing a loan or getting a loan from them. Debt and equities can both be securities, and many people often think, oh, if they're simply making a loan to me, it may be exempt, and very often that's not the case, and trouble develops long down the road. There are many exemptions from the registration requirements that may be available to make sure that the company doesn't have to become public and do a public offering. Regulation D is the most common one that's used in the United States on a federal level, and many states have counterparts to the Regulation D rules. And you may have seen in the recent news that the Securities and Exchange Commission, the SEC, has approved allowing public solicitation to accredited investors in certain offerings. That is true, but it's not true that many of the states have adopted similar exemptions as well. And so until the exemptions are enacted across the United States, we certainly encourage people to be very cautious about any kinds of public solicitations when they're trying to raise their capital. Make sure that you work in conjunction with experienced securities counsel to be sure that your offering is in compliance with those securities laws.